Kyle, and good morning, everyone. I hope everyone is staying well and healthy. My name is Bruce Wiener. I'm the Executive Director of Bridge to Justice, a local nonprofit law firm here in Boulder, and I practice primarily family law.
And I'm Evan Branigan. I'm a Boulder domestic relations practitioner for many years, Branigan Family Law.
All right, so I just want to address a couple of housekeeping issues before we get started. Judge Salomone, Judge Sierra, and Magistrate Haenselman will present on various family law issues relating to COVID-19 for about 25 to 30 minutes. And then the remainder of the time will be a Q&A. So for people who want to ask questions, please utilize the chat function. For me, it's on the right side of my Zoom screen, and Evan and I will select and read the questions for the judges. Please be mindful that judges cannot answer questions about specific cases you have or give advisory opinions, so please keep that in mind. And Judge Salomone is the presiding civil judge this week and may need to leave the CLE a bit early, but otherwise we have a hard stop at 1:15.
Okay, so this presentation is basically just going to be a Q&A and a presentation with the judges. Bruce and myself and Jennifer Walker are planning to put on sort of a tips and tricks, practice tips, pointers for unique issues that are coming up during this time. We will probably schedule that for next week or the following week, so please keep your eyes open for that, and we look forward to seeing you then. Before we get started, I wanted to thank Kyle and Laura at the Bar Association. They are wonderful. They've set all this up and we are rocking and ready to go. So with that, I'm going to introduce our judges. We have today Judge Sierra, Judge Salomone, and Magistrate Haenselman. And I'm going to throw it over to you.
All right. Thank you very much. I also would like to second my appreciation to the bar for coordinating this in relatively short order. If you think back to where we were a month ago, I don't think any of us could have envisioned the circumstances under which we are working today. And as I think about what occurred that weekend of March 13th, and everything just developed so rapidly, and that continues to be the case. But that particular weekend, things were changing not only day to day, but it was really hour to hour that things were changing in our world. There were considerations as to what effect coronavirus was going to be affecting Boulder County. And when it became clear that there had been individuals who had been at least secondhand come into contact with individuals at the Justice Center, I think that Judge Bakke was considering how we were going to keep safe individuals who were in our staff and those members of the public who were coming into the Justice Center. And before there had been any word yet from Denver, from Justice Coates, from the governor, from anybody in DC, I think that Judge Bakke was thinking about our staff members and the members of the public who were going to be entering the Justice Center and thinking about what she could do. So that weekend of March 13th, she contacted the judicial officers and said, on Monday, I don't want any staff to come into the building. I only want supervisors and judicial officers. And then our directive that Monday was we're going to be closed down altogether. Monday, Tuesday, and Wednesday. Your marching orders are to vacate all settings that are on your docket except for essential settings, those that are an emergency. And we worked collectively, Magistrate Haenselman, Judges Butler, Salomone, and I as team domestic relations, and we put together what we thought was going to be the manner in which we were going to operate for some period of time. And then the next day we came back to a different setting in that Justice Coates then issued what has come to be known as the March 16th Justice Coates order. And that order suspended all court operations. And he said, I am ordering that except for a very concrete type of cases, he was directing that there be no court operations taking place. And then he extended that by an order that is dated March 20th indefinitely. He did indicate in his order, he said, because the courts of this state are tasked with protecting the basic constitutional rights of the citizens of the state and with providing a forum for addressing matters essential to their safety and well-being, I ordered that the following classes of matters or operations may not be suspended and will continue in the state courts throughout this period. And relevant to what we do, he directed that temporary protection orders continue to be heard, and those that are granted then proceed to permanent protection order hearings, that motions to restrict continue to be heard, that mental health hearings also proceed, emergency guardianships, emergency conservatorships, emergency restrictive protection orders, the ERPO, the red flag hearings, those are continuing to be heard. And he also said that each judicial district was to proceed to consider those matters going forward, either by video or telephone with limited in-person contact. Judge Bakke then issued on that same date an order, administrative order 2102, in which she then also, following the guidance from Justice Coates, also closed down the Longmont Courthouse altogether and indicated that only those categories of cases that Justice Coates had indicated would go forward during the period of time and she did put a time period, whereas Justice Coates said indefinitely. She indicated in her administrative order that non-emergency matters would be rescheduled by the court for dates after May 31st, 2020. That is the date that is in her administrative order. More recently, you saw circulated in the Bar newsletter, and you also saw posted to the 20th Judicial website, information as to exactly what it is that we are doing. And I'd like to, having talked about how it came about, this is what is taking place. There are 3 district court judges any given week and 1 county court judge at the Justice Center. The county court judge is taking care of the jail reviews. The district court judges, 1 is appointed to be the duty judge, 1 is the criminal judge, and 1 is the civil judge. The criminal judge is hearing the felony cases, and those are all done by video. There is no attorney, no defendant, no deputy who is in the courtroom with the judge. The duty judge is sitting right past where the deputy sheriffs sit. And when an individual comes up to the courthouse and says, I'd like to file for a temporary protection order, or I am here for a permanent protection order hearing, then there's a telephone number that's posted at the Justice Center door. That rings right where the duty judge is sitting. The duty judge screens the phone call and speaks to the individual. If, in the opinion of the duty judge, the individual is presenting a colorable temporary protection order case, then the individual proceeds to be permitted entry into the Justice Center to either be heard if the application has been completed or to complete the paperwork for a protection order, and then proceeds to appear in person before the civil judge, who is hearing the protection orders, reviewing the motions to restrict, hearing the mental health hearings, and those are being heard by telephone, and then hearing any permanent protection order hearings that were granted 2 weeks prior, 14 days before. From staff perspective, We only have 3 staff. There are 6 supervisors who are alternating 3 at a time, 3 working from home, providing them support, and then 3 working at the Justice Center. Our remaining staff do not have state-provided equipment in the way of either telephones or computers, such that they can be conducting business from home. The state is also fairly guarded appropriately as to the security of various systems and what can be opened on private computers. And staff at present is not working from home. And so to the extent that judges are generating orders, and many of us are, it is not with the assistance of court judicial assistants and law clerks. The remaining judges, I've indicated that there are 3 of us at any one time at the Justice Center. The remaining of us are working from home, either working on orders that are ripe and in our inboxes, or that we have from prior hearings that we have not completed, or there are some of us that are working on special assignments that Judge Bakke has assigned. There are decrees that are being signed. There are any number of Qdros and those types of matters that are ripe coming through our inboxes, where there are 2 lawyers in a case and pleadings are becoming ripe. We can absolutely address them. The difficulty has become where there is 1 attorney and 1 pro se litigant, because what is not taking place is we don't have staff to upload the pleadings that are being mailed. If there are any pleadings being mailed, we can't tell, by pro se litigants. We don't have the staff to do that at this time. But as the effort remains for people to remain sheltered and to minimize community spread, I'm sure that you, as I do, read conflicting reports as to how long it's going to take to be safe. We just don't know when we're going to be returning to the Justice Center. Team DR has vacated hearings through the end of April. We've not, as of yet, vacated any hearings into May. I have issued an order indicating that, at least as to my settings that are scheduled for the week of May 11th, at this point in time, it may be unlikely that those go forward, but we just don't know. And then now to talk about what may happen when we do resume operations and how we may go about resetting all of those hearings that we have vacated, as well as those hearings that perhaps were not set, but that we know require settings based on motions that we have reviewed and that we've indicated we're going to be setting for hearing, is Judge Salomone.
Thank you. So I have the second chapter of our planned discussion, which is where do we expect to be and what do we expect to see happen when the court reopens. And as Judge Sierra said, we don't know exactly when that will be. If you've read the administrative order, the current administrative order that Judge Bakke issued says that the first day back for resumed regular settings is after May 31st. But of course, the situation's evolving, and so we don't know if we will be looking at returning before that, or returning after that, or returning right on that date. But to give you all a vague idea of the challenges that we're going to have when we come back, the DR divisions collectively, the 3 divisions, 1, 12, and 14, not counting the Magistrates division, have maybe vacated a ballpark of about 50 cases per week for each of the closure weeks. And when I say 50 cases, I'm talking about all 3 of the divisions together, and some of those are the 15-minute ISC hearings, but others of those are 2-day permanent orders hearings. And so if we think about the likelihood that we're looking at 11 weeks of closure, and that's the March date that we started through the May 31st date, if that ends up being the date. What we're talking about when we return is having somewhere in the ballpark of about 500 cases that were bumped and vacated and then need to be reset when we open again, if everything that was originally vacated requires a new setting. There's a wrinkle that makes things even tougher, and that is that the district court criminal divisions, of which there are 2, have also bumped a lot of trial settings. And as a district court group, Judge Bakke expects that we will all, as judges, give attention to the cases that need to be reset first, even if they are outside of our normal assignment. And so what I'm trying to tell you all is that there very well might be a number of criminal jury trial settings that are up against speedy trial deadlines and will require the attention of the DR judges instead of resetting our ordinary DR dockets for the first several weeks back. And we don't know the number that might be yet. We don't know who or how many judges would necessarily be required to hear them. But the upshot of all of this is that there's a possibility that we may not be, as the 3 district court DR divisions, beginning to set or reset any of our DR trailing docket hearings until potentially well into June. And I say potentially well into June because of the fact that if we come back at the beginning of June, and then there are several weeks where the DR judges are presiding over the more pressing criminal issues, then the new settings for DR wouldn't be heard until after that point, could be well into June, could be even later. So there are a handful of changes that we've made to try to accommodate the coming back process and make things move a little bit more smoothly. Some of those are as follows. If you practice a lot in Boulder, you might know that there are 2 weeks in June and 2 weeks near the winter holidays that are called open weeks. And we generally don't set anything during the open weeks in any of the district court divisions. Those open weeks for this year are the 29th of June and the 6th of July. So nothing is set in any of the district court divisions right now during those open weeks. And we are looking at a likelihood, assuming that we're back in normal operations by that time, that we're going to abandon the open weeks and offer settings during those open weeks just because we need them. It also turns out that by complete happenstance, the 3 DR judges are all in scheduling during the summertime. So Division 12, my division, was not setting anything the first 3 weeks of June because I was the scheduling judge for those 3 weeks. Division 14, Judge Sierra's division, had initially not been scheduling anything for July because that was her set of scheduling weeks. And Division 1, Judge Butler's division, was assigned to scheduling in August and so would not have been setting anything for 3 weeks in August. Because of the need to catch up again, we're planning on opening all of those scheduling weeks to settings, at least a limited set of a limited set of settings. So it may not be the same number that would be offered on an ordinary trial week, but all of the divisions will be offering at least some settings during the weeks that we ordinarily wouldn't have when we were scheduling. Another thing that we are fairly certain that we're going to be able to offer is the availability of firm settings with Magistrates Haenselman and also Magistrate Collins, who is our magistrate. And those would be available for more than what the ordinary set of issues are that are generally heard by the magistrates. If parties consent to magistrate settings, then we will be doing or offering firm settings as their schedules allow for some permanent orders and also some post-decree issues, including those that involve children that would not normally have been heard by the magistrates, but will now in order to help us catch up. A final thing that we're kicking around because we've been mindful of the concern about the issuance of orders is that in some cases, if the judge rules from the bench once the hearing is held, the FTR transcript might serve as the copy of the written order that the parties will get in lieu of the lengthy minute orders that you generally get, just because we're trying to push in as many hearings as we possibly can, which means that we'll have less writing time. Certainly not all cases will be appropriate for a transcribed ruling. Complicated financial matters are unlikely to have rulings from the bench any more now than they were in the pre-COVID timeframe. But in some cases, you may hear a judge say to you that your minute order will be skeletal and you are to order the transcript of these proceedings for the written order. Lots of people have asked, well, once we restart normal operations, how are we going to offer settings and resettings? And so if you hear me and retain one thing that we tell you in this whole audio conference, do not bombard the CJAs when they return to the office trying to get resettings. This will not be a free-for-all, and there will not be a first-come, first-serve resetting. As I said, there may be hundreds of cases that need resettings, and so the CJAs will almost certainly be under instructions from the judges that say, don't answer parties who reach out to you faster. You reach out to the parties. And so our request to you all that are hearing us is that when the CJAs return to the office, don't bombard them, wait for them to reach out to you. We've been talking about resetting in a pecking order of the type of issues that are implicated by a hearing that was either bumped and needs to be reset, or also the things that were never set but became ripe during the limited operations period. And so when we say that we're doing a pecking order, by statute, relocation cases need to be fast-tracked, and so those will likely to be set or reset, regardless of when they became ripe, in the first priority of settings. In a close behind that group priority of settings is likely to be cases that have issues regarding children and or have instability that's caused by domestic violence or instability that's caused by emergent financial circumstances. Cases involving children are almost certainly going to be set and reset before cases that are purely financial and cases where there is no emergent financial situation. There is going to be discretion by each of the individual judges about when we want to set something. And so we will all anticipate that we're going to be looking at cases individually, one by one, to try to get things set in the order that they really need attention. And I totally understand, we all totally understand that everyone who represents a client is managing that client's worries and expectations and feels like their matter is a matter of ultimate urgency. We entirely understand that, but the way that we are obligated, I think, as judicial officers to look at our own dockets is to manage the imminent concerns that fell probably just short of the essential type of operations that would have been heard during this COVID period, but are emergent regarding children, unstable regarding domestic violence, have public safety issues or safety of an individual citizen at their core. And so understand that the likelihood is that those are going to be the cases that will receive the earliest settings. I also have in my portion of the outline a question that was asked prior to coming on and chatting and asking all the extra chat questions. And that was a question about how will the court take into consideration the economic and practical realities that the parties are facing, including the state stay-at-home order, when determining financial and parenting related issues. And the question asker put in parentheses that we understand that the answer to this is likely going to be it's a case-by-case issue. And it is exactly like you thought, a case-by-case issue. But as we could probably give to the practicing attorneys in some general areas. And so, first of all, we can tell you that the 3 judges in the DR rotation agree that the governor's stay-at-home order does not allow parents to violate standing parenting time orders. So if you all represent clients who are asking, do I really have to go to the transition because there is a stay-at-home order in place? Can I withhold the child from the other parent because I'm not supposed to be out of my house? The answer to that is that the Team DR agrees that the answer to that question is no. And there is an explicit part of the governor's stay-at-home order. If anybody wants to geek out on sections and subsections, it is section 3, which under B defines necessary travel. And it says that necessary travel includes travel required by law enforcement or court order. And so we all believe that transitions are expected to occur, including travel for those transitions. The second general area that we have general agreement on among the 20th bench is that parenting time for a parent who has a higher than average risk of exposure to COVID or a higher than the co-parent risk for COVID does not per se constitute an imminent threat to a child for the purpose of a motion to restrict parenting time. We haven't actually gotten very many such motions, which is kind of a pleasant surprise, I think, for us. But I know that there are a number of articles that are coming out in different courts or citing to different court orders throughout the country that say some courts are changing custody orders to remove children from the households of parents who are healthcare workers or who are law enforcement or firefighters on the grounds that those folks are at a higher risk of infection than an ordinary citizen or a higher risk of infection than the co-parent. So you should all know that we are not issuing those kinds of per se orders here, and you should not expect that any of us will issue those kinds of orders. And if you are the proponent of a motion that would seek to restrict the other parent's parenting time because that parent is a higher risk of exposure for any of the reasons that I described, you should expect that you will need to connect parenting time with that higher risk parent to imminent harm to the health of the child in question, particularly in light of what the research and the statistics seem to indicate about what the likelihood is of a not immunocompromised child falling seriously ill from COVID. So this is not to say that Judge Salomone says that's not getting granted, because everything is on a case-by-case basis. But a proponent of such a motion should definitely expect that they're going to need to connect the safety of the individual child or the danger of the individual child to the parenting time with the parent. And that is not a per se connection as far as this bench sees it. So that is all I have. I see a bunch of chat questions, but I think that what we had preferred to do is get through each judicial officer's prepared comments and then loop back to some of those chat questions at the end of the presentation. So take it away, Ms. Haenselman.
Okay, so 2 things. One is my internet keeps telling me it's a little bit spotty, so the screen is freezing from time to time and I'm not seeing everything. So I'm just going to let you know that now if I stop talking in the middle. The other is thank you all for being here, and I hope that you are all healthy and your families are healthy. And it's just such a difficult time, and I just appreciate all of you wanting to participate today. The first question that I was asked to address in the outline really has been addressed by both Judges Salomone and Judges Sierra, which has to do with how are we resetting. And we're going to be working together and triaging cases to set in a way that is the best that we can do and the most appropriate for each case, and it's not going to be perfect. As you know, Division M handles most of the non-contested hearings. We do some adoptions, we do initial status conferences, temporary orders, modifications, and then we will be setting some contested permanent orders hearings with consent. And we will make ourselves available, and we're going to set, giving the priority to the cases that need to be set first. But we're already starting to look at ways to set. We are still seeing memorandums of understanding come through. We're still seeing stipulations. ODR mediators are mediating over the phone. I'm sure that other mediators are. And so to the extent possible, keep working on those stipulations, because those are coming through. And I did have a chance to look through some of the chat as it was coming through, and there was a question about domestic relations orders, and those are coming through. And when they're filed by attorneys, we're seeing them and we're addressing them. So, so the JPOD function is still working. However, when it comes to motions filed or responses filed or replies by pro se parties, those have to be filed by mail, and we simply don't have the support staff available to be able to address all of those. So motions are not ripe if we don't have those documents filed by the other parties, by the pro se parties. The other issue that we had a question about was deadlines, and the forward-looking deadlines, the deadlines that come into play when a motion is filed with the court. So for example, exchange of CRCP disclosures, 16.2 disclosures, those deadlines remain in place, and as Judge Bakke has ordered, and we will also consider motions to enlarge those deadlines. And there was also a question that I saw regarding or leave of court with pre-decree motions, and certainly when assistants aren't available to set phone conferences, I believe we'll all be giving some leeway with pre-decree motions. However, please do confer. And so before you file that motion, please indicate that you've conferred with the other party before filing. And you may reach an agreement regarding the enlargement of time. So enlargement of time for forward-looking deadlines that are triggered by the filing of a motion, those remain in place and would need to be extended by the court. The backward-looking deadlines, those deadlines that come into play when a trial date is set, if the court has vacated the hearing because of COVID-19, then those deadlines are also vacated, and you wouldn't need to file a motion to request an enlargement of time given that the hearing has been vacated. So those backward-looking deadlines that are triggered by the hearing date, those would be vacated without your needing to file a motion. The other question that I was asked, and I may have not understood fully how the question was asked, but anticipating filing motions to modify due to changes in circumstances resulting from COVID-19. And those, as with any other motion to modify, are going to be addressed on a case-by-case basis. We're 1 month in now, and as we all know, we have no sense of how long this is going to last. And so those motions will be addressed on a case-by-case basis. And then the other question that, again, I think has probably been answered was, has there been an impact on filing by CFIs, by PREs, PCDMs, those pleadings that can't be filed, or those documents that can't be filed through JPOD? And yes, just like filings by unrepresented parties, just like filings in JV cases that need to be filed by mail, there is absolutely going to be delay, and we all know that, and we are considering that when we're looking at pleadings that have been filed. And I think that is everything that I had that needed to be addressed. And it looks as though Judge Sierra has been answering a lot of questions that are coming up on chat, but I guess I'll put it back now on Mr. Branigan and Mr. Wiener as to how you want to address those, or Judge Sierra.
There were actually a couple of questions that were on my script that I totally skipped. So before we get to those, if I could come back to these, there were some questions ahead of time that were submitted to us. Those are the ones that we've been answering. So one question was, CJAs don't seem to have email access. How do we get the court's attention while they are out? And I think we've answered that the CJAs, in fact, don't have email access. And the best way to get the court's attention is when you e-file. I believe that the three of us and Judge Butler are seeing everything that attorneys e-file fairly, if not contemporaneously, within hours, literally. So if there is anything that you need us to see, you can file a motion, a status report, a request, if it is appropriate to share it through ISIS and serve it upon opposing counsel. That is, at this point in time, probably the only way to get the court's attention if it is appropriate to do so through e-filing. There then is a question that asked about attorneys filing motions to restrict, and that also would be done through e-filing. And the paperwork for a protection order would be done through e-filing and then just coming to the Justice Center to be heard for a hearing. There's a question that said, should attorneys still be filing motions for issues that are not considered a priority or safety, with the expectation that the court would set those matters for a hearing once it resumes normal operations? What process should attorneys be following for the court to take up with matters after this is over? Should we be following up with the CJA, file a request to set, or wait for the court to contact us? My suggestion would be that yes, you can absolutely be filing motions if there is an attorney on the other side and it's a matter that becomes right. You can expect that there, well, could be an order issuing. And if it is appropriate for a hearing to be set, it's going to go on the list of hearings that we're going to be discussing with the CJAs for setting. And during the triage system that we're going to be working also with our law clerks on while we are working from home, and having them assist us in determining the issues that are involved in each of these cases, the system that Judge Salomone discussed. Those cases will also go on that roster. And so it is well possible that a case that is filed, say now, may have a higher priority than a case that was already on the schedule to be heard in April and was bumped, based upon the issues that are involved in each of those matters. So those were the two questions that were on my list that I skipped over. Thank you.
Okay, so unless the panel has anything further to discuss, I think we're going to turn it over to Q&A, and Evan and I will go through the questions. So the first question is from Greg Greenstein. Will cases that are currently scheduled for permanent orders hearing in June, July, August, and beyond be continued by the court in order to allow cases that were previously scheduled for permanent orders to be heard when the courts reopen for non-emergency types of hearings? I believe each of you addressed that, so I'll let you decide who wants to take that question.
That seems to be a slightly different question. If I'm reading it correctly, it seems to be a slightly different question than what's going to be set or reset first. I think I understand that question to mean if a setting exists on the docket after the court reopens, would it get bumped to accommodate a higher priority setting? And I think the answer to that is not necessarily, but that a lot of, so a question that we haven't completely explored yet is, ordinarily, as you all know, we set a lot more on the trailing docket than the group of judges could actually ever hear from the trailing docket. And because of the existence of the trailing docket system, we've never had to bump anything that called ready before because of a lack of judicial officer. I'm not sure that that's going to be the case anymore. And so while I would not say that it is likely that a existing setting in July or August would be bumped from its trailing docket setting in order to accommodate something else, if we are in a position where we cannot hear everything that we have set for a given week, I think that the importance of the substantive issues would likely get considered in a bump.
And Greg, my guess is that that's very unlikely, because that would create even more disruption than we're dealing with. So unless it's absolutely necessary, probably not.
Okay, I have the next question, which is from Peril. The question is, would the court consider allowing non-contested hearings to go forward via phone or Webex in cases where there's one attorney and one pro se party? This may be a question for Magistrate Haenselman.
And to refine the question, is that before the court resumes full operations?
I guess so, or I guess
and I'll
maybe
go
both
ahead
ways.
and so at this time, the only matters that are being heard are the essential hearings, are the public health hearings that have been previously defined. So we're not having any phone conferences, any WebEx hearings of any nature until we resume operations.
Okay, thank you. The next question is from Scott Hammerslaw. And the question is, will cases which involve children have priority over financial/dissolution without children matters when the court reopens? I believe Judge Salomone, you directly addressed that issue.
Right. So we will expect to be looking case by case. And I don't think it would be fair to say as a blanket issue that if children are involved, that would always supersede a case with emergent financial circumstances. So we're going to look at them all case by case, but as a gross generalization, we will likely move cases with contested parenting time more quickly than cases where only finances are contested.
Okay, the next question is from Helen Tellerton. How is the bench addressing the increase in domestic violence within households? Individuals are still being arrested and processed and released under conditions including mandatory protection orders and conditions that prohibit the return to the family home. For the protected party, how are their rights to file for separation or divorce affected by the existing administrative orders?
I think that dovetails a little bit with a question that I see lower down from Patricia Riley about her experience being that dissolution petitions are not being accepted at this time. And that's actually completely news to me. I suspect that there is no blanket order that says no one can file a dissolution petition right now, but it is very possible that they're not being processed because we have so little staff in the building.
So they are being processed, but they're being processed at a slower rate than usual. So as you see them accepted, as I said, we're on JPOT all the time on ISIS. and we can accept most pleadings except for the new petitions, the new filings. Those have been taking up to a week to accept. So the rate of accepting them is slower. As far as the initial question, there have been communications with SPAN over the course of the last week as to what the availability is for domestic violence counseling, because that is something that I'm sure all of us have been reading about. And we know from our training about the difficulty of being in a home with an abuser and how common it is for those tensions to spark up when there is economic strain in a family, when you are instructed to stay inside in a home, and all of those conflicts that have been at bay can be very difficult to manage. The courts, for that reason, have been available for any civil protection orders, and having been the civil judge, the duty judge, I would tell you that the vast majority of the protection orders that came through involved former spouses not living together rather than current spouses. I don't know, Judge Salomone, what your experience has been this week. So that was surprising to me. And I'm not quite sure what that says. But as far as the availability of the court system, we are working under Justice Coates' instructions, and there is the right to file for divorce and separation. And there is this availability of SPAN counselors for any domestic violence counseling.
Okay, the next question is from Catherine Bright. Should PREs and CFIs hold on to reports until settings have been rescheduled, since they can only be mailed for filing? Or would the court prefer that attorney, if there's an attorney on the case, that the attorney file the report from a CFI or a PRE or a BCBA? I believe Magistrate Haenselman, you addressed that issue. Do you want to take it?
I'm sorry, my internet's been cutting out and I couldn't hear you at all. And I apologize, my screen keeps freezing. So if you'd like to say it again, or it might be one of the questions that was asked. Who was it that asked?
This is from Catherine Bright.
Is it conducting home visits?
No, it was asked at 12:36 p.m.
I think one of the judges typed an answer to the question, which is that these can be e-filed by counsel. And I think another judge I read said also to just mail them into the court. They're still being processed, just not as quickly, but you should not change your procedure on that. And I assume this probably applies to Beth Ornstein's question about mediation certificates as well.
Right.
Just keep mailing it, and it might take a while for it to register on CCE online.
Yeah.
Right,
But
so Judge Salomone had the experience of having a pleading that was mailed. And so she had the date stamp where it had been received on a particular date and then uploaded into ISIS on a date that was maybe 2 weeks later.
It was 2 weeks later.
Pardon?
So I was just going to add, we have been struggling with trying to figure out how much mail, if any, is getting through. And all four judicial officers have been watching carefully to see what we're getting in our inboxes from unrepresented parties. And of all the unrepresented parties that we have expected filings from, exactly one unrepresented party pleading has come through that we can confirm for sure. And it took 2 weeks from the date when the unrepresented party said that he mailed it until it was stamped and uploaded into JPOD. So that's not
that also would be the same circumstances for ODR certificates, mediator certificates, and CFI PRE reports. but I don't know that it makes any difference to hold on to them, because they're still going to end up in the same stack of paperwork that needs to be ultimately uploaded.
Okay, next question is actually sort of from me. I think I saw somewhere communication about parenting classes and how that issue is being handled. Maybe Judge Sierra, could you address how the court is approaching that issue?
Sure. Certainly both of our providers indicated that they would not be conducting those any longer due to the need to engage in social distancing. And so we've approved all parents who have not already completed the parenting seminar doing the online parenting class. And there were 2 online parenting class providers that we were already utilizing when parents were residing out of state or just out of the jurisdiction. So all parents are able to now complete that online. We do not, however, receive from those providers a list of participants as we do with our local providers. So whereas for the local providers, it's not necessary for the parties or counsel to provide us the certificates. For the online providers, it will be necessary for counsel or the parties to mail us the certificates, because otherwise we will not know about your attendance. We did circulate the links to those providers through the bar, but if you need to, we will also post that on our website, and you can obtain that information on the 20th Judicial website if you need it for any case.
Okay, the next question, I don't think this has been answered already. This is from Lila Soul. Are there any suggestions for handling financial emergencies that do not qualify as a TPO or motion to restrict? For example, indigent parents suddenly without income due to separation and in need of temporary child support or maintenance. Is it frowned upon to file the motion for temporary orders for emergency financial circumstances, even though not under the matters to be heard under current policy?
So I'll field that one. So going back to the other question regarding conferral or filing a motion pre-decree without leave of court, go ahead and file. You can file the motion. It's going to come through JPOD, and but in terms of if the question is will it be heard, then then I fall back to what the current administrative order is regarding what matters are being heard. But confer with the other party and file the motion, and you won't need to have leave of court to do that. We're not going to be holding people to have leave when there's no way to reach out for the assistance at this time.
And I would add that I don't think it's frowned upon to file the motion as emergent. It's not going to mean that it will be heard if it doesn't fit under the essential issues that are in the administrative order, but it does help flag for the court that perhaps it should be given careful thought for assignment as soon as regular hearings reopen.
Okay, we've got a couple more questions in the queue. We have a hard stop of 1:15, so if anyone else has any other questions, please type them in the chat box, or if you're having any trouble with that, you can email myself or Bruce, but we're happy to get to all your questions. I have a couple more already, so let's see. Catherine Bright asks, the court to please address conducting home visits and child interviews electronically by CFIs or PREs. Is this okay? Is this left to the evaluator's discretion, or is this ill-advised? That's the question.
Everyone's volunteering at
Yeah,
once.
I think it does have to be left in the discretion of the professional. I was surprised to see that there were still a few supervisors of supervised parenting time already with established relationships with families who were still conducting that. Given the circumstances, I think that that's a difficult job to be performing at present. I know that Children First of the Rockies initially suspended entirely and then moved to doing electronic parenting time. There were many families in a lurch, and there continued to be some families who were doing, for example, not supervised parenting time, but maybe supervised transitions, who are still in difficult circumstances as a result of that. I think it would be very difficult to do, for example, a supervised home visit electronically. And depending upon the age of the child, it would be less feasible to do an electronic child interview. And understandably, it may be, if it's the first meeting, perhaps a little bit more challenging to establish rapport, but also, understandably, safer for both the professional and the child.
Thank you. All right, the next question is from Jennifer. Is travel by a parent in Colorado to another state to exercise parenting time in a state where COVID is very widespread considered essential travel? What if a parent or child is at higher risk because of diabetes, immunocompromised, etc.? I think Judge Salomone, you may want to take this. You address motions to restrict.
So again, emphasizing the case-by-case basis. I would say that if there is a court order that obligates one parent to travel to the other state, then it is essential travel, notwithstanding whether the location in the other state is or is not a hotspot. You added to the question, what if a parent or a child is at higher risk? If a child is immunocompromised, then that is a special situation that the court should probably hear with respect to the imminent safety question. We have talked amongst ourselves about if a parent or another individual in a home with a child is immunocompromised. The judges on Team DR don't believe that the restrict statute allows us to restrict parent A's parenting time with a child because parent B has a immunocompromised individual in the household who isn't the child, because this is not a question about imminent threat to the child. It's a question about imminent threat to someone else in the house. And so be aware that the court would really be looking specifically at what is the evidence of imminent threat to the child and only the child.
And there's also a question as to exactly what evidence is available at present of the child currently being immunosuppressed.
Okay, I want to go over sort of a question Mike Miner asked that I think Judge Sierra, you addressed, but I want to just clarify to make sure everyone got this answer. So Mike asked about our DROs being issued or QDROs for para because of deadlines. Judge Sierra, you indicated that the courts are getting those and processing them. It just might take a little longer. But I think you said that when filing, we can communicate urgency if there is a deadline. So I think I'm hearing from you that if you're an attorney who filed something and it's really urgent and it's not been gotten to, I think Judge Sierra, you're saying, well, let us know by filing a motion, just saying, hey, I filed this and here's the deadline, and that will get the judge's attention. Is that pretty much?
Yeah, I don't even think that a motion is required. I know that there's a way of adding a comment when you e-file. I know that I see those comments either to the clerk or I see them on ICES where you say thank you or send this to the division. At this point in time, there is no staff. It's literally us that are receiving those filings. And so just put that message on there and we're seeing that.
Okay, so this question is from Patricia Linville, and this also relates to the court's limited operations and staffing. My experience is that the clerk's office is not accepting new case petitions, resulting in an inability to file other documents into the case, such as return of service or a stipulated case management plan. When will new case petitions be accepted on CCE?
So we've addressed that. They are being accepted, but at a slower rate than other filings because only the supervisors can accept those.
Okay, quick question from Sean Eddinghoff, who asks, per the Judge Baki's administrative order, hearings are to be rescheduled after May 31st. And the question is, does that mean that all permanent orders hearings in May are automatically continued, or could that situation be revisited before the end of April?
We have not vacated permanent orders throughout May. At this point in time, they're still scheduled. We just don't know. I think that we maybe are looking for the May 11th settings. Certificates of mediation are due April 20th. So we probably would be visiting maybe a week before that and making a decision as to whether those cases are going to be affected, and we're likely to do a week or two at a time rather than just saying everything in May is going to be cleared, because we want to, if it's appropriate, retain any cases that can be retained on the docket.
Okay, the next question is from Rachel Latimer. Is it the court's position that video for everything can be ordered by the court over the objection of the parties? For example, CFI, PRE investigations, and depositions.
When?
It's unclear in the
So
question.
at this point in time, we have a public health emergency, and the court's position would be yes. That certainly would be, I believe, the court's position, that the court is not going to risk the community's health and the health of staff if participation can be accommodated by video. And then at other points in time, it just really depends as to what the risk is.
And I don't know if part of the question has to do with would the court do so? And I think that if the issue is a non-essential issue and there is a good faith argument for a continuance rather than proceeding by video, that the court would certainly consider that. But I think the first half of the question, does the court have the authority to order that everything happens telephonically or by video over the objection of the parties if it needs to hear something essential? Yes, that's the court's position, that it can do that. That is not to say that it always would.
So for example, I considered early on if hearings were going to be held by video, whether I was going to be putting the parties in a situation where their attorney would want to meet face-to-face in their office. And I didn't want to create a scenario where there was going to be transportation taking place and really going against the goal of limiting community spread. And that's something that I can't control. I can say it's not the court's wish that this take place, but I don't know that I can keep that from happening.
Okay, quick follow-up to you, Judge Sierra, about the QDROs and sort of typing a note to clerk. Beth Ornstein asked about how to handle that for pro se parties, and wonder if there's an answer to that. There may not be.
And the question is, how can pro se litigants inform the court of urgent QDRO deadlines?
Yes.
They can submit the QDRO and indicate that they need a certified copy as quickly as possible. The difficulty will be just having the QDRO put on the system, could be a matter of weeks.
All right, the next question is from Patricia Riley. Is there anyone available to fulfill requests for certified copies of pleadings or orders?
No.
I don't think there is, yeah.
Okay, Carol Glassman asks, are discovery deadlines and witness disclosure deadlines that have passed for hearings that have been vacated to be reopened as a backward-looking deadline? And I believe we addressed that, and the answer was yes.
Yes, they were cleared automatically along with the trial setting.
Okay, I don't believe there are any more questions. Bruce, do you have any more questions?
I don't.
Okay, so I just want to give another plug. Bruce and I and Jennifer Walker are going to be doing a practice tips in the age of COVID-19 CLE, probably next week, maybe the week after. It'll be the same kind of format, so keep your eyes open for that. Wanted to thank again Judges Sierra, Salomone, and Magistrate Haenselman. And I also wanted to thank Kyle and Laura, who have been working in the background to get all this running smoothly. And that is it for everything today.
Hope to see you all in person soon. Take good care.
Thank you.
Bye-bye.